As members are aware, an interagency committee led by MCCY together with MND is conducting a comprehensive review of the framework, the CDMF. The goal is threefold: to encourage pro-social behaviour, facilitate amicable resolution of disputes between neighbours, and third, to deal with this as far as possible at an early stage. To achieve this, we are looking at enhancements in three broad areas. First, as I said, early intervention, by building consensus through community norms. This will set shared expectations on acceptable community behaviour, set out standards to help shape this normative behaviour in the community. SMS Cement will share more details of this when she speaks at MND's COS. Second, and I think we all know this, despite setting these norms, having these standards in the community, nuisance might still occur. In fact, very often they will likely still occur, perhaps at a reduced rate. The overall aim is to encourage, as far as possible, conciliation between neighbours as much as possible. Let me explain MNLaw's work in the third area, which is in enhancing and improving the dispute resolution framework. As I said, and even as we look at steps to enhance and improve this process, I said earlier that we intend to channel as much of these disputes as possible through the mediated conciliatory route. That, I think we all accept, is the best way of resolving a neighbour dispute. But given that there will be a number of these intransigent cases, we will work towards strengthening the powers and the processes of the CDRT, the Community Dispute Resolution Tribunal, which some members spoke about, so that it can provide faster and more effective relief in the appropriate cases. Mediation can preserve and often even strengthen the relationship between neighbours by providing them with a platform in the hands of a very good trained mediator to resolve their disputes amicably in very much a win-win fashion. To improve the take-up of mediation at an early stage, we plan to mandate mediation for three categories of cases. First, mediation will be mandatory for certain types of community disputes, and penalties will be imposed for not attending mandatory mediation. So, for instance, if you're required to go through a mandatory mediation and you don't, then the cases will not proceed at the CDRT. Second, for voluntary mediation cases previously mediated and settled at the CMC, but the mediated issues have resurfaced, or there's a new dispute related to what was mediated previously, the CMC will be able to mandate remediation. Third, as I said earlier, we will in general require disputing neighbours to undergo mediation before they file a case at the CDRT. This will prevent disputes from unnecessarily escalating to a court process. After we make mediation mandatory, the 80% figure that I cited earlier may well come down. To give mediation more standing and teeth, we will also create a mechanism for settlement agreements mediated by the CMC to be registered and enforced as a CDRT order, provided certain conditions are met. And we'll set out those conditions after we've studied that and introduce this.